at trial in a civil lawsuit here in New York, if you lie when you are on the witness stand, will it make a difference in the outcome of your case? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I'm out for a walk today. It's a beautiful day today here in Great Neck, and I had a few minutes to share this great information with you. Let's say you sued your doctor for medical malpractice, and your doctor denies all of your allegations. So now your case proceeds throughout the litigation process, and 2 or 3 years down the road, your case finally comes up for trial. And now you take the witness stand and explain to the jury exactly what happened to you and what injuries you have as a result of this doctor's carelessness. All right. So now it's time for the defense attorney to get up and question you. And one of the questions the defense attorney asks you is, "Hey, Mr. Jones, have you ever been convicted of a crime?" And in the heat of the moment, you turn around in a reflex reaction and say, "Of course not." And he says, "Are you sure?" And you say, "Of course I'm sure." He says, "Have you ever been incarcerated?" And you say, "No, of course not." "Have you ever been in jail for a number of years?" "No, I haven't." And then he begins to ask you some background questions, such as, is this really your name? Are you known by any other names? Is this your real birth date? Where were you born? What's your height? What's your weight? And now you think, okay, why is he asking you this information? Well, what you don't realize is that he's asking you for a key critical reason. He's setting you up. He wants to make sure that you are the same person that he knows is described in the records that he has in front of him. In this scenario, he knows that you were convicted of a crime. He knows that you did time in jail. And importantly, he also knows that you just lied to the entire jury and to the court and to everybody in the courtroom. He knows all that. So now, what's the next step for him to do once you deny all of those things? Well, he doesn't just come right out and says, "You're a liar, sir. I have paperwork that shows that you were in fact in jail, that you were in fact convicted of a massive crime, a very serious crime." No, that's not what he does. Instead, he's going to set you up to show that you are a liar without actually having to say that you are a liar. He's going to show that you are not being truthful for something that really has nothing whatsoever to do with the claims that you have brought against this particular doctor. And in the moment that he asked you whether or not you were convicted of a serious crime or convicted of any crime, your immediate reaction was, "No, of course not," because you didn't think that he would know it. You didn't think that he would do a background search on you. You didn't believe that there was any way he could possibly find out what happened to you, let's say 20 years earlier, and that you did a number of years in jail for something stupid, okay? You didn't believe any of that. So now, what does he do? Now he asks you background questions to confirm that you are in fact the same person as listed in the documents that he has. Then he's going to ask the court to take judicial notice of various records that he has subpoenaed into court, various records from the Department of Corrections, to confirm that on a particular date and at a particular time, you were in fact an inmate incarcerated at a particular prison for X number of years. He's then going to offer to the court and ask the court to take judicial notice that you are in fact the same person described in those documents as you have just testified to. He's then going to go ahead and introduce documents into evidence and ask the court to take judicial notice that you are one and the same people who was convicted or pled guilty to this serious crime for which you were sentenced to a number of years in jail. So what have you done here? What you have done is totally destroyed your credibility. And you should know something. In these civil lawsuits, your credibility means everything. If your credibility is shot, if you have destroyed your credibility by testifying falsely or by showing that there are inconsistencies in your testimony, what you are doing is whittling away at the only thing you have available in your case. The facts are not everything. The only way that you can show that the facts are true or more likely true than not is by establishing credibility. And if you have no credibility, how can the jury expect to believe anything else you have to say? And that is a critical component of these civil lawsuits in New York. And it doesn't matter whether it's a medical malpractice case, whether it's an accident case or wrongful death case. Credibility is the key to every single one of these cases. Because remember, in each of these cases, there are clear factual disputes. You say something was done wrong, the The person whom you have sued said, no, I did nothing wrong. You claim that the wrongdoing caused injury. The person you have sued said, no, anything I did not cause your injury. So there are clear factual disputes. And ultimately, the jury at trial will have to decide who is more believable. Are the facts as you present them more likely true than not true? If the answer is yes, then you'll get a verdict in your favor. If the answer is no, you will lose and you will get nothing. So now if you have gone ahead and whether it's intentionally gone ahead and misled the jury and the court, whether it is unintentional, whether it was mistaken, regardless, if you go ahead and testify falsely, if you go ahead and testify to something that is less than the truth, now what have you done? You've created a problem with your credibility for which you likely will not recover from. So why is credibility a big issue? Credibility is a tremendous issue. And in fact, at the end of the trial, the judge gives the jury a specific legal instruction, and it's called falsus in uno. And that's a fancy Latin phrase that basically says to the jury, okay, listen folks, if you find that a witness has testified falsely about just one thing, you have the legal right to disregard part of their testimony or all of their testimony. That's a critical legal instruction about credibility. Now, if the jury has decided that you are a liar, if the jury has decided that you lied about something, even if it's not significant, they can disregard some or all of your testimony. So why do I share this with you? I share this with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have questions but have not yet started a lawsuit, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.